Hi, we've got one more lecture for this week, and I know 2 lectures in 1 week is way too much. This particular chapter, which is chapter 3, and it talks about the court system and alternatives to dispute resolution, is long and it's kind of dry. So I'm going to break it up into 3 very short lectures, so you're not sitting here for maybe 45 minutes listening to me try to explain, and I think this may help a little bit. So part 1 is going to be about the court structure and the jurisdiction. We're going to answer these 3 questions, which are the objectives in the chapter. One is judicial review. The other one is about jurisdiction. And finally, what's the difference between a trial court and an appellate court, which falls under the court structure. So let's get started on this one. The first question that's asked is, what is judicial review, and how and when was the power of this review established? Basically what this is it's a process that says the courts decide the constitutionality of legislative enactments or actions by the executive branch. And this pretty well kind of falls to the Supreme Court, correct? And it was established, it's always been implied, but in 1803 it was established with Marbury v. Madison, in which Madison stated it is emphatically the province and duty of the courts to say what the law is. And that's sort of the precedent that's been set. Courts interpret the law, and then they determine remedy if the law has been broken or not. Then there are 2 or 3 authors of the Federalist Papers. Both abdicated this concept, and those two of the main ones were Alexander Hamilton and James Madison. And it was decided that this judicial review is needed for the checks and balances in our democracy, so that nobody gets more power or can allow that power to corrupt them. So that's how this all began, and here's a question that's going to come up on the screen. It's a true or false. It talks about judicial process by which the court decides the constitutionality of legislature and actions by the executive branch. And an example of this would be the upcoming review of the Affordable Health Care Act, when it talks about the state exchanges. Is that true or false? So, after we have come down to the conclusions that the court's reason for being is interpretation of the law, then we have to come and decide how or who can come before the court, and that comes down to being called the jurisdiction. What is the authority of the court to hear items? And it's pretty well laid out. It's kind of interesting. There are 2 major ones that come to mind. One is the personal jurisdiction, or the geographical jurisdiction. Does the court have the authority to hear the dispute from the people involved? Did it happen within their geographical area? An example would be, can I pull a lawsuit that happened in Indiana and take it to Hawaii because the weather's nicer there? Obviously that's not going to go very well. But the law in question, or the offense in question, needs to be within the locale of the court system. And there are 3 or 4 questions asked. Did it happen in the region of the court? Can the long arm jurisdiction be applied? And did the contract originate in the region of the court? Locality is very important. Subject matter is very important. Does the court have the right to hear this? Is this their particular area for talking about a dispute? Limiting issues may be the amount, as we'll see here in a minute, the nature of it, type of crime, misdemeanor or felony. Is it to be in state court? Is it to be in federal court? all of those things have to be looked at before filing a suit or a case in court. Two other things that you need to be very well aware of. There's something called original jurisdiction and appellate jurisdiction. Original jurisdiction is where the first hearing takes place, and that's usually in a trial court, where the original case has been filed. After that case has gone through this court, then it will show up in the appellate jurisdiction. And the appellate or appeals court is where verdicts from the original jurisdiction will be heard and decided if there's been any error in interpretation of the law or any error in the procedure of the court in general. So that kind of sets your jurisdiction up overall. Now let's look at the federal court jurisdiction, which is fairly well defined, okay? It has to be a violation of the U.S. Constitution, of a federal statute, or regulation, or a treaty between the U.S. and one or more foreign countries. Those are the ones that are going to show up in the federal court jurisdiction. And there's a diversity jurisdiction, it's called, that says if it's a controversy that involves dollars, it has to be over $75,000. If it is a controversy between citizens of different states, like a corporation, it will show up in federal court. If it's a foreign country, and if it's citizens of a state or citizens and subjects of a foreign country. So it is dealing with inter rather than intra-state issues. And then there's jurisdiction in cyberspace, which is kind of dicey because the locale can be a bit of a problem with cyberspace because the World Wide Web is just that. It's worldwide. So the personal jurisdiction is a function of geography, correct? So sometimes there can be a case where, let's say the company is sitting in Indiana, and the case may be filed in Montana or whatever because they were bought via the internet rather than in a regional manner. So there's competing views when you look at this, and basically what it comes down to, and this is being used more and more often, is a sliding scale. First of all, if the business does substantial business over the internet, I mean if they do a majority of their business over the internet, then yes, they may be able to be sued from a different location. If there's only some interactivity between the website and within the website, it's sort of a judgment call at that point. If the website is just simply doing passive advertising and there is no sales being done via the website, then the jurisdiction is going to lie where the company's main headquarters are. But as you move out, see the sliding scale, it gets further and further out, where you could file a suit in Minnesota for a company who's based, let's say, in Florida, that deals mainly on the internet. So that becomes a matter of judgment. The other issue that you start looking at here is venue and standing as you look at whether a case can be filed in court. Venue is in what district or what area, the appropriate location for the trial. A very good example of this is the issue with a hog farm or a confinement farm and a, oh good lord, what is the name of it? I forget the name of it. That's awful. Anyway, there is a hog farm that wants to go next to a. It's sort of like a summer retreat for people, and the hog farm sits in White County, and the retreat sits in Tippecanoe or in Carroll County. They want to file the suit in Carroll County because it would be to stop the hog farm, because they feel they would have a unbiased venue there, rather than in White County where the hog farm is sitting. It's a matter of where the violation or the action happened at. In this case, I think this one went to the Indiana Supreme Court, and they said they had to have it in White County because that's where the hog farm was going to be put. And then the other thing that you have to look at right here is if there's a sufficient stake in the controversy. That means, is there a basis for this case? It can't be a moot thing, it can't be hypothetical, and it can't be academic. Is it real? Is it substantial? So if you can, these two have to be met. You will see change of venue for some criminal cases where they don't feel that they can get a fair trial in one area. They will change that venue. Usually the venue has to be, getting a venue changed has to be fairly drastic. And here's a question that'll come up on the screen. True or false? Jurisdiction is determined by the physical location and subject matter. Is that true or false? Now we get to some more sticky part of this chapter. It's talking about the state court systems and how they are set up. That's not working. Now let's go and we'll look at the state court system. Now let's review just a bit so you can get this all in your mind. The jurisdiction for a state court system is personal, the geographic, and subject matter. And it can be limited in the amount, the nature, or the type of crime. So this is the criteria for being able to enter this system. Now, in a state system, you have trial courts, and they will either have a general jurisdiction, which means they're empowered to consider anything before them, as long as they're within that region, or they can have a limited jurisdiction. And this would be, you may have family courts, you may have juvenile courts, which would be limited jurisdiction. And that would come from the subject matter here. One thing you must remember about the state court systems, they're all different. Usually, though, they both, or most states will have a trial court, which would be what? The original jurisdiction, the jurisdiction of origin. And they're going to have appellate courts, which are courts of appeal. Now, first, a case has to come through the trial courts. Then, if the verdict from the trial court is not what was required or what was wanted by the plaintiffs or the defendant, they could appeal. Either can appeal. And that would go to the appellate court system. And at the intermediate area, in the middle, the appellate courts have to hear the case. They have to look at it. And what they look at when it's appealed are questions of law. Not questions of fact, but questions of law. That means, was the procedure right? Was there no violations of rights? Things of that nature for whatever the appeal is bringing up. Was the law interpreted correctly? Not were the facts correct. And these are your courts in the middle. They have to hear the appeal. Now your Supreme Court, your state Supreme Court, has discretionary review, which means they can look at it and say whether they want to look at that case again in court. So we have trial courts, we'll have appellate courts, and then we'll have usually a state Supreme Court that has the choice of hearing the appeal or not. Now that's your state system. That's fairly well forward. And now you get to your federal system. And again, let's bring up the jurisdiction. Okay, these are going to be violations of the Constitution, federal statute or regulation, or a treaty of some sort between countries. The amount has to be over 75,000. We've got to be between different states or dealing with a foreign country. And this system's set up with U.S. district courts, and these are, again, trials of general jurisdiction in each state. You'll have the U.S. Court of Appeals, and that's an automatic right to appeal. Then you'll have the U.S. Supreme Court, and it is the same way as far as Supreme Courts go. They do not have to look at each case that is appealed. They will literally look at the case, review it, and at least 4 justices have to agree to it before they will review that, which means 4 justices had to look at the case of the Affordable Health Care Act and say, yes, we need to look at that it needs to be an interpretation of the law. Now, here's another question. True or false? A trial court is used to appeal decisions from the appellate court. Is that true or is that false? And I think we're at the end of part 1. And yes, we are. Okay, thank you.